Hi folks, my name is Greg McLaughlin. I am the Affidavit of Support lawyer. I've spent the past 10 years representing plaintiffs in federal litigation to enforce the USCIS Form I-864. Today, what is the duration of I-864 financial support? Well, this is actually set forth very clearly by the federal regulations at 8 CFR 213A.2. It's also right there in the Affidavit of Support itself. There are 5 different things called terminating events. And after the first one of these 5 events occurs, the Affidavit of Support is terminated by operation of law. What does by operation of law means? It means that you don't have to do anything extra. So for example, USCIS, the immigration agency, doesn't need to produce a stamp saying the Affidavit of Support has terminated. After one of these 5 events happens, the Affidavit of Support is simply done as a matter of law. Excuse me. So what are those 5 terminating events? We'll go through each of the 5 of them, but really there are only 2 that you really need to focus on in probably 95% of these Affidavit of Support cases. So the first 2 are that the Affidavit of Support terminates when the beneficiary becomes a U.S. citizen or has 40 quarters of work as determined under the Social Security Act. Okay, the first one of those is pretty straightforward, right? When you go through the immigration process, the first step in family-based immigration is that you become a resident. So after the immigrant visa process or the adjustment of status process, the first legal immigration status that somebody acquires is a resident. Now that person can be a resident for the rest of their life if they want to. However, after 3 years in the case of marriage-based residency or 5 years in other forms of residency, the person can apply for citizenship. That's called the naturalization process. If that person naturalizes and then becomes a U.S. citizen, that terminates the Affidavit of Support. What you need to hear, though, is that nobody ever has an obligation to naturalize, and lots of people choose not to. So, for example, some countries in the world do not allow their citizens to become dual citizens, that is to say, to hold citizenship in 2 countries. So India and Japan are prime examples of that. Lots of Indian nationals, when they become U.S. residents, don't want to apply for citizenship because that destroys their Indian citizenship. And so if they're thinking about ever wanting to go back to India in the future, or Japan if they're a Japanese national, they might decide to just be U.S. residents forever because that gives them most of the rights that they would have as citizens. This is to say that when you're thinking about the duration of the Affidavit of Support, you cannot assume that somebody will become a U.S. citizen in the 3 or 5 years where they are eligible to apply for citizenship. So they could apply for citizenship in that window, but they don't have to. And I can tell you as an immigration lawyer that lots of people don't apply for citizenship when they're eligible for, either because they don't want to or they just don't get around to it. So that's event number 1 out of 5, become a U.S. citizen. It might occur 3 to 5 years after becoming a resident, or it might never occur. Second terminating event is acquiring 40 quarters of work. Now, I hear all the time from immigration lawyers even that the Affidavit of Support terminates after 10 years. That is just incorrect. The statute and the regulations are clear that it terminates after somebody has 40 quarters of work. Well, 40 quarters, 4 quarters of work per year, 10 years you might say. What's the difference between 40 quarters of work and 10 years? Well, you acquire quarters of work only if you're working. So if the sponsored immigrant isn't working, they are not making progress towards that 40 quarters. Now it gets more complicated because under the Immigration and Nationality Act, the sponsored immigrant can also be credited with quarters of work earned by their U.S. citizen spouse during marriage, but during marriage if the marriage continues. What does that mean? That if the couple is divorced, those quarters are not credited. So you might say, okay, they've been married for 8 years, the immigrant was working 2 years, her U.S. citizen spouse was working 8 years, 8 plus 2 is 10 years, great, the affidavit is terminated. But if that couple gets divorced, the U.S. citizen's quarters of work are no longer credited. And guess when the affidavit of support usually gets enforced? It's during or after a divorce. So as a sponsor, one should not count on that quarters of work attribution as the thing that's going to cut off the affidavit of support. So it's not 10 years of work, it's not 10 years period. It's 40 quarters of work that terminates the affidavit. So that might happen 10 years after somebody gets residency if they've been working consistently, or if they are not working consistently, that 40 quarters of work might take much longer than 10 years, and it might never happen. Typically, it's one of those two events that I just discussed that will account for the termination of the affidavit. The other three events are as follows, and they are more rare. Terminating event number 3 is if the sponsored immigrant loses status as a resident and departs the United States. That's something called a conjunction. So both of those things have to be true in order for the affidavit to be terminated. For example, if the sponsored immigrant leaves the United States, but but has not lost green card status, that does not terminate the affidavit. I had this asked by a federal judge not very long ago. My client had been out of the United States for a long time. That did not terminate the affidavit because she was still back in the United States eventually and still had her green card. Likewise, if somebody has lost their green card, even via a deportation order, that's an order of removal, that does not terminate the affidavit until the person has left the United States. One scenario that I see a fair amount is when somebody has conditional residency status. That's the 2-year status called CR1 status. Well, if you are a CR1 resident and you forget to file the I-751 petition at the end of your 2 years, you lose your status. You lose your status as a resident. Does that terminate the affidavit of support? No, it does not, because the regulations say that only termination of status and departure from the United States terminates the affidavit of support. So a lot of times in this litigation, the defense will try to raise some sort of argument that my client, the plaintiff, has lost their status or changed their status, and that doesn't matter. As long as the person gained status originally based on an application that included the affidavit of support and is still in the United States, even if they've lost their residential status, that does not terminate the affidavit. So that's terminating event number 3. Number 4, I have never seen. I've been doing this for 10 years and I've never seen it. If somebody is placed into deportation proceedings, also called removal proceedings, and in removal proceedings raises the defense of adjustment of status. So they get placed into removal proceedings and they say, aha, but I've remarried and my new spouse will file a new I-130 petition for me. And in removal proceedings, I will file a new I-485 adjustment of status application. And if I need to, my new spouse will file a new affidavit of support. If you go through the whole green card process again in deportation proceedings, that terminates the original affidavit of support. I have never seen this. If you have seen it, I would love to hear about it, but I've never seen that happen. Theoretically, though, if somebody is placed into deportation proceedings and gets a new green card, that ends the affidavit of support. The last of 5 terminating events is the death of the I-864 beneficiary. So once the green card holder dies, that terminates the affidavit of support. It's not written as clearly in the regulations as one might think, but if the I-864 sponsor dies, that also operates to terminate the affidavit of support. So if either of the two of them dies, that terminates the affidavit. However, the estate of the I-864 sponsor would be liable for all damages up to the time when the affidavit of support sponsor dies. I've seen one case, I believe one case ever where an estate was sued under the affidavit of support. That's also pretty rare, but the law is clear. Once the beneficiary or sponsor of the affidavit dies, that terminates the affidavit. But that, folks, is it. Those 5 events are the only things that terminate the affidavit. Just to run through them one more time: naturalization, that is, the beneficiary becomes a citizen. 2, the beneficiary has 40 quarters of work under the Social Security Act. 3, the beneficiary loses residency status and departs the United States. Number 4, this weird thing where the beneficiary gets a new green card in deportation proceedings, never seen it happen. Or number 5, the beneficiary dies. Those are the only things that terminate the affidavit of support. Divorce does not terminate the affidavit of support. It says it right there on the affidavit. Also, because federal regulations set forth these 5 terminating events, federal courts, including the Western District of Washington, Central District of California, 11th Circuit Court of Appeals, the 7th Circuit has held on something very similarly. All of those courts have said that standard contract defenses do not apply in the affidavit. What does that mean? If you're a sponsor who is sued under the affidavit of support, you cannot raise the types of defenses one would typically raise in contract disputes. A common one is fraud. So if sponsors want to argue that they were defrauded into marrying an affidavit beneficiary, she never loved me, she just married me for a green card, etc., that defense is disallowed by federal courts, especially following the Belovich decision in the 11th Circuit. This is clear law. There is no federal case law to the contrary. So the bottom line, those 5 terminating events that I discussed are the only things that end a sponsor's liability. Standard defenses are not a way out of liability. And in reality, if you're taking a practical approach to this, the things that are most likely to terminate a sponsor's liability under the affidavit are number 1, that the beneficiary becomes a citizen, or number 2, that she obtains 40 quarters of work as calculated by the Social Security Act. Hope that's helpful. If folks have additional questions about the affidavit of support, you are welcome to reach out to me in the comments. I will answer general questions there. If you are the beneficiary of an affidavit of support and would like a confidential case consultation, we do that by video call all throughout the United States. Hope that's helpful. Have a good week, everyone.